Robert Munroe and Robert Maxwell. They're going to be discussing ethics in arbitration. Bob Munroe is with Ross McBride in Hamilton. He's a specialist in the civil litigation field. He is in private practice. For the past 10 years, he's been counsel to the Metropolitan Toronto Real Estate Board. Metropolitan Hamilton Real Estate Board, pardon me. And for those of you, again, I'll repeat for those of you that may not be familiar, the province is divided up under the Canadian Real Estate Association is across Canada. Each of the provinces, I believe, has a real estate association. There is OREA. And then under Ontario, there are a number of different real estate boards. The Hamilton one is one of the largest, as is the Toronto Real Estate Board, and as Ottawa is as well. But there are a number of other boards as well. Robert Maxwell is with Gardner Roberts. His paper, as well as his biography, if you haven't picked it up, is at the back, at the table out here at the front. So please pick that up on your way out. Robert Maxwell does administrative law and civil litigation at Gardner Roberts. He's counsel to the Toronto Real Estate Board, also known as TREB. For the last 6 years, he has counseled TREB and also appeared at ethics and arbitration on behalf of TREB. He also has done litigation for TREB as well.
Thank you very much. I'm glad that there was a correction that it's the Hamilton Real Estate Board that I work for. It's probably a little known fact outside of Hamilton that it's a defense to an assault charge, a lawful defense to an assault charge to be accused of being from Toronto if you're really from Hamilton. So luckily we were able to clear that one up. It's a pleasure to be here today to spend a few minutes speaking about ethics and arbitration before local boards. At the outset, I'd like to acknowledge the fact that over the years I've been able to discuss these topics in some detail with the executive director of the Metropolitan Hamilton Real Estate Board, Karen Meeker, and her assistant, Cheryl Condello, and also recently with the in-house counsel as opposed to the out-house counsel over here. I beg your pardon? I don't know what to do about that. Do you want me to stop for a minute?
The monitors are not working?
I think I look better in real life anyway. In any event, to Charlotte Sloan, who's the in-house counsel at OREA, the Ontario Real Estate Association. I've had some very helpful conversations with her, and I certainly acknowledge that any of the good parts of my comments certainly come from her, and she's not responsible for any mistakes that I make. What I'd like to do is really speak about a number of general things that I think will be helpful in the way you approach ethics and arbitration, or the way you advise brokers in approaching ethics and arbitration. I can tell that there are certainly people here who have a great deal of experience, and I hope that the things I say aren't too mundane, but sometimes I think when dealing with lawyers there are some basics that I notice people miss, and I thought it would be helpful to cover some of those. The first thing that I'm going to deal with, and I'm not really following my paper in any particular order, so is just to highlight the difference between the Toronto arbitration and ethics procedure and the ethics and arbitration procedure that's followed in the rest of the province. Most boards in Ontario follow what can be called the 1994 OREA recommended standard local board bylaw. In other words, it's a bylaw that has been essentially drafted by OREA in consultation with people in the industry. And the bylaw is a standard bylaw. Toronto has, particularly with respect to ethics and arbitration, developed their own bylaw, and that's what Bob Maxwell is going to be dealing with. So when I speak about what's in the bylaw, of course I'm referring to what's in generally speaking, in the standard area bylaw that has been adopted by most local boards, including the Hamilton Board. I don't propose by any means to take you through the procedural or substantive contents of that bylaw, because if you are acting for a broker, you couldn't get away with relying on a summary that you would pick up at a seminar like this. You would have to be certain to get a copy of the bylaw, make sure that you have the current bylaw, read the sections of the bylaw, read the sections of the ethics code, the Korea Code of Ethics, if that was what the prosecution was about, but make specific reference to the bylaw. And the reason I say that is that for lawyers, there are provisions of the standard form bylaw that I might call counterintuitive. In other words, they're not provisions that you would, if you just assume you know, well, it's got to be like this because that's what the Law Society regulations would be like, or that's what the some of the other professional codes would be like, you may run into trouble, and I'll give you a couple of examples of that. Representation by counsel, by a lawyer. As lawyers, we probably assume, well, look, if I show up at the hearing with my client and it's a hearing, they're gonna listen to me, everybody's entitled to be represented by counsel and so on. In the standard form bylaw, you need to give 5 days written notice of your, the member has to give 5 days written notice of the fact that he's actually going to be appearing with a lawyer, all right? So it would be kind of embarrassing to not realize that and show up and either have the hearing adjourned because you hadn't done what you were supposed to do, or perhaps not be able to take part in the hearing. That's the same at arbitrations. You have to give 5 days written notice of your intention to participate in an arbitration if you're a lawyer. Another one is the obligation to arbitrate. There are provisions of the standard form bylaw that require arbitration between broker firms with respect to commission disputes. And in the standard form bylaw, there are, of course, time limits for initiating the arbitration procedure. Probably once a year, if not more than once a year, I end up dealing with a situation where a lawyer has, a friend or a good client who's a broker who's come to him and they've got a commission dispute with another brokerage firm, and the lawyer kind of wades right into it, issues the statement of claim, and off he goes suing for the commission. And waits too long so that he gets past the 3-month time limit for initiating an arbitration under the standard form bylaw, only to find that perhaps the other side is astute enough to realize that, look, you should have been arbitrating and not suing. That's bad enough, but in addition to that, the way the bylaw works, if you took that step of suing instead of arbitrating, it's also a violation of the bylaw. And if you're a member of the corporation, you're bound through contract to abide by the bylaws. That might result in disciplinary proceedings being initiated against your client. So, because he decided to sue instead of arbitrate. There are obligations to disclose information that are found in the bylaw. Again, to some extent, I think counterintuitive. If a discipline procedure is initiated and what happens is that under the standard form bylaw, the organization of disciplinary proceedings is similar to what you would expect as lawyers. It's similar to the Law Society kind of procedure. There's a professional standards committee that's responsible for receiving complaints, investigating complaints, and then making decisions as to whether or not those complaints warrant a prosecution before the discipline committee. It's a similar kind of process. But the investigators, who are called researchers under the bylaw, are allowed to go to members and require members to produce documents or information to them that's relevant to the complaint. And the bylaw is quite specific that if you don't comply with that request by a researcher for information, that you're in violation of the bylaw and subject to professional standards proceedings yourself. So as a lawyer, if you had a broker come to you saying, well, you know, this is what they want me to do and I don't want to give them the documents and so on, and you didn't consider the provisions of the bylaw, you might end up giving advice to your client that would result in disciplinary proceedings. Of course, I'm not going to get into some of the refinements of these things. Obviously, in this production of documents question or production of information, there may be some privileges that you could raise, like solicitor and client privilege and so on, but generally speaking, I can't highlight enough the importance of looking to the bylaw for these types of things. The other thing that's important to consider in the bylaw is the type of penalties that can be imposed. And essentially, they range from reprimands to fines to suspension of certain services to termination of membership in the association. So these things are quite serious. Now, because I have 5 minutes left, what I sort of want to do is jump ahead to something that I haven't heard discussed at these seminars, and that's the Prohibition Order. And maybe everybody's aware of the Prohibition Order, and maybe everybody's read it, but sometimes I think it's like War and Peace, the book War and Peace. Everybody talks about it, everybody says it's a great book, but nobody's read it. And maybe some people in here have read it, but I haven't. It is a great book, though. Anyway, in the paper I point out some of the basis for the power of boards to regulate their members. And as some of you know, and anybody I think advising brokers should know, there was a consent prohibition order in 1988 in the Federal Court of Canada Trial Division, a consent order signed by Justice Addy, A-D-D-Y, that's available to you, I'm sure, from CREA or AREA if you wanted to get a copy of it, that sets out very specific provisions for the regulation of the real estate industry, and particularly the practices of local boards. And with respect to ethics and arbitration, there are provisions in the order that deal with the ability of a local board to control the conduct of its members, and particularly paragraphs 6G and H. 6H says specifically that a board may terminate membership on the basis of complaints from the public in the case of members who are proven not to be able to serve the public on a regular and consistent basis and provide such services in accordance with standards of competence and integrity necessary to serve the public. So there is, I think it's important to know that. They, under paragraph 6H, can also refuse to admit somebody as a member of a local board who doesn't meet certain standards of integrity. And in paragraph 7C of the Prohibition Order, there's specific authority granted to allow for arbitration and conciliation of disputes by local boards. I've referred to the Prohibition Order in the paper, and I've also referred to some cases that have considered the Prohibition Order, because I think that if I was acting for brokers in ethics and arbitration proceedings, I would want to know very thoroughly the contents of the Prohibition Order and the interpretation of the order by some of the court decisions. The final thing that I'll say that I think is important for people to consider in these ethics and arbitration matters is the extent to which the Arbitration Act 1991 applies to the procedures that you take and govern both arbitrations at a local board level and discipline hearings at a local board level. I think an argument can be made that the bylaw is in fact an agreement to arbitrate under the Arbitration Act, and therefore the provisions of the Arbitration Act may be triggered for both disciplinary hearings and arbitrations. And I think that's something that often people don't consider. And it may be an area of debate, but it's certainly something that as representing a broker, I would want to think about when helping a client. Thank you very much.
I think that I'll stay over here if for no other reason as Elizabeth has these signs, and I can probably avoid these time limit signs if I stay over here. My comments relate to the Toronto Real Estate Board and the ethics and arbitration procedure there. There are two separate committees, one arbitration and one ethics, and essentially TREB is a corporation. There is no, members of TREB do not exercise a statutory power of decision, such as a statutory tribunal, such as the Ontario Labour Relations Board, but it's simply by agreement that people are there. And the ultimate remedy for TREB is to kick the person out, either at ethics or in arbitration if they fail to comply with an award, subject to the provisions of the Arbitration Act about complying with awards. So it's a private corporation, not a statutory board, and therefore not a statutory tribunal. That means the SPPA, for example, does not apply to these hearings because they're not exercising a statutory power of decision. It means also on review questions, you cannot go to judicial review at the divisional court, where we would normally go from decisions of administrative tribunals, statutory tribunals, because there is no statutory power of decision that is exercised. And therefore, by Section 2 of the JRPA, that is the Judicial Review Procedures Act, you can't get into divisional court. And an obvious point perhaps, but one worth mentioning is, only members of the Toronto Real Estate Board can be parties to an arbitration or to an ethics hearing for that matter, because it's the only individuals or firms that the board could ever have jurisdiction over by contract. I mean, the Supreme Court of Canada has said the bylaws in effect are the contract between the members in a case called Chenoweth and the Montreal Real Estate Board, and therefore the jurisdiction derives from contract. And having said that, the two committees then are arbitrations, the Arbitrations Committee and the Ethics Committee. And arbitrations are governed again by the contract, which is the bylaws, and in particular at TREB, Article 21 of the bylaws says that all disputes between members over commissions has to be arbitrated before the Toronto Real Estate Board's Arbitration Committee. In other words, if two realtors get into a dispute over a commission, they have to go to the Arbitrations Committee. They cannot sue as a condition of being members at the Toronto Real Estate Board. So there are three threshold issues if you're involved in arbitration at the outset. The first is there a dispute within the meaning of the bylaws? If there isn't, then they won't take jurisdiction because there's nothing presumably to arbitrate. And a dispute essentially is, there's a definition of dispute in the bylaws, but it essentially is any dispute over a commission. So usually that will be met, presumably, when a realtor comes in your door and says, I got a problem, I think I'm entitled to commission and I haven't been paid. The second point is both parties have to be members of TREB. That is, they're not going to arbitrate a dispute between a vendor and a realtor. It has to be a fight between two realtors. And the third is make sure you make the limitation period, which is 60 days under the bylaw, to bring a claim. And a claim is simply, in letter form, setting out why the claimant thinks they're entitled to a portion of the total commission in a transaction. Now, once these threshold issues have been met at arbitration, the next question is, well, what is it that gives a person an entitlement? Assume for a moment a selling agent has not been paid. What gives them an entitlement to the commission? And the answer is at the Toronto Real Estate Board versus all the other boards that I'm aware of in Ontario, one of the main principles is that the Toronto Real Estate Board uses the principle of first introduction. And that you'll find if you're involved in one of these disputes in the guidelines. Now, first introduction is simply this. Assume for a moment on the MLS system there's an invitation, or there's a listing, and the cooperating broker, that is the person who handles the selling side, is offered 3% of the commission. A selling agent goes out and introduces the property to a person, takes them through the home, for example, in residential, and then 2 weeks later, the same purchaser goes back to the house with a different selling agent, and an offer is put in through the second selling agent. Then the question is, of the two selling agents, who gets that selling portion? At the Toronto Real Estate Board, depending on the circumstances, it may well be the first agent, that is the one who didn't complete the transaction. In other words, the second selling agent who completes the deal, who procured the transaction, will face an arbitration claim by the original agent who showed the property. And the idea is at the Toronto Real Estate Board is that first introduction is a principle in which entitlement to commission may be proved your case. So in other words, if it was simply procurement, which is the sort of standard in most of the other boards in Ontario, it would always be the selling agent who actually procures the transaction. At the Toronto Real Estate Board, it's not necessarily the case. In fact, it would be often the person who first introduced the property. Just as far as procedure, there's an arbitration panel. It's a very informal process where the arbitrators sit at a boardroom table, quite literally. The parties give their sort of side of the story. They're allowed cross-examination. There's questions from the panel, and then a decision is given within 1 day. The entire process will be a few months. It's much more expeditious than the courts, and a lot cheaper. Even assuming that lawyers are retained, the process is going to be over in relatively short order. In fact, in my time in the last 6 years, when I've been involved in arbitrations, I don't recall any of them being over a day long. And some of them, when you're into ICI transactions, are for fairly hefty sums of money on major commercial transactions. The two things you should be aware of when you're doing arbitration is read Article 21. That sets out the procedure, and the board has to comply with that procedure. The second thing is there are arbitration guidelines that all members of the board have, and those will be of paramount importance when you're dealing with an arbitration claim. The other issue is that of review. Assuming you represent a client and they say, well, we don't like the result, what happens? And the bylaws have specifically excluded the Arbitrations Act, which is permissible under the Arbitrations Act. And that means you're only entitled to a review under Section 48 of the Arbitrations Act. It's a mandatory provision. There is, therefore, no right of appeal to the courts, and you would end up in the Ontario Court General Division if principally the issue was the board failed to follow the bylaws or there was a breach of natural justice. Those would be the two principal grounds on a review. With respect to ethics, the ethics procedure is governed by Article 22 of the board bylaws. Those are the provisions that bind the board and the parties. They set out the procedure, and there are essentially three stages, potential stages. One is the Professional Standards Committee investigates essentially a complaint. The complaint can be by a member of the public, by a member of the Ethics Committee, or by a member of the board. If it's decided that there should be a hearing, there will be a statement to the respondent, that is the person charged with a violation of the provision, what they're charged under, that is the Code of Ethics, for example, and the factual allegations as to the conduct that is complained of. Again, there's a hearing in which the board acts as a prosecutor in certain circumstances, or the member opposing acts as a prosecutor. It's before, again, a panel, the ethics hearing panel, and the ethics hearing panel makes a determination, and it can range from a fine of up to $50,000, suspension, expulsion, or a reprimand. There's a wide range. If the respondent, and the respondent only, is unhappy with the result, they are permitted to appeal to the Ethics Appeal Committee. It's another tribunal, another domestic tribunal internally at the Toronto Real Estate Board. There would be transcripts from the lower hearing. There would be the documents before the lower hearing, and it's quite literally on the record that was before the Ethics Hearings Panel. And again, it's a committee of members. The unusual aspect about the appeal is it is only the appellant that appears and makes the pitch as to why they should be found not liable under the particular provisions they were charged with, or alternatively, why the fine or penalty, whatever that may be, should be reduced. Now, as far as a review from the Ethics Appeal Committee, if your client was unhappy there, the place to go would be the Ontario Court General Division by either application or action. And there is good law to the effect that, in fact, the board could be exposed to damages, for example, for acting improperly, outside the scope of their bylaws, or for example, and that's by the Supreme Court of Canada in a case called Chenoweth and the Montreal Real Estate Board. It's also been held to be applicable by the Ontario Court General Division, Mr. Justice Steele, in a case called MacDonald and the Windsor-Essex Real Estate Board. So it's up to, but the normal remedy would probably be a declaration that the decision is a nullity, and that would be the review process. And given that I think my time is now up, those are my comments.
Good morning. This is not the usual forum that I stand to speak about the Universal Agreement of Purchase and Sale. I think over the last 3 or 4 months, I must have spoken to at least 5 or 6 different forums, most of them being small or medium-sized brokerage firms describing the differences between the old Agreement of Purchase and Sale and the new Universal Agreement of Purchase and Sale. Actually, the Universal Agreement of Purchase and Sale was an initiative launched by OREA back in 1994, and I remember in the summer of 1994 being up in Bracebridge and discussing it with a number of real estate salespeople and the broker in that area. Now, just before I start, there's a couple of points that I'm going to bring to your attention. First off, I'm keeping in mind here that most of you are legal practitioners who basically get derived business from real estate brokers, and those of you that are real estate broker and real estate sales representatives, I will be directing some of my comments right now more to the lawyers than to you. But what I'm going to attempt to do as I go through here is when I use the term real estate salesperson or sales representative, I'm going to use that to describe the actual agents. I'm trying to avoid the use of real estate agents to describe the salespeople because I think it causes a lot of basically confusion, especially with agency disclosure and things of that nature, and they do prefer now to be called salespersons or sales representatives. Brokers are basically under the Real Estate and Business Brokers Act. The brokers basically have the people who are working for them are salespeople or salespersons under the Act, and the broker is the one who owns the office, owns the franchise. That's the broker. Now, someone asked me an interesting question, and I don't have an answer to this, but with all these learned colleagues of mine that are around here, someone asked me where they could get the Universal Agreement of Purchase and Sale in a machine-readable or a computer disk form. I don't know if you know, or you know, Merv? Oh, you do? Okay. If you could perhaps give us some indication here as to where they could get it on in a computer format.
There are several producers of computerized forms that OREA does not necessarily recommend in quotes, but acknowledges that they're alive. And OREA has brochures, and your realtor clients can get them for you. The packages are typically about $150 for the standard forms package, which would include the offer, all of the forms that I mentioned earlier. Wait until January, because January the 1st, they revise all of the forms. So if you want to save a few bucks, just wait a couple of months.
And Treb?
I'm not sure the process, but I think you can just call Treb and purchase them. Excuse me, sorry.
In a
Just call Treb.
hard copy,
I
or?
think you could get them, certainly in hard copy, and then download them if you want.
Yes.
Is there any breach of copyright, for example, if you simply
The question was, is there any breach of copyright by putting it into their own computers? And I suspect that from my past dealings with most of the boards, they would likely say yes. And they guard their forms, but they have designed the Universal Agreement of Purchase and Sale for use by everyone. And Merv was mentioning there are going to be changes that are coming out as of January 1st with respect to the Ontario Real Estate Association, and I did not include them in my paper because at the time I did my paper, they had not yet been approved, and I did not hear back from my contact at the Ontario Real Estate Association, so I'm assuming that these changes have been approved. One of the new changes, as of January 1st, 1997, is at the bottom of the OREA form, it is going to say in January of 1997, OREA standard form, do not alter when printing or reproducing the standard preset portion. The concern is if the people just take them and put them on their own computer, they will just start customizing them again. And this is one of the reasons why they brought forward the Universal Agreement of Purchase and Sale, was to create some kind of standardization in the real estate industry and also through the legal community as well. Because everyone had their own forms, all the different boards had their own forms, Treb had their own form, the OREA, a lot of the boards used OREA, but some of the individual boards, such as London and Ottawa, had their own forms. I believe Hamilton did as well, a lot of the larger boards. So that if you do something like this, you probably are going to be in breach of copyright, but again, this is what they designed, the purpose of, for the universal form, was it was going to be used not only by sales representatives, but by lawyers. And you'll see if you go through my paper, which I'm not going to read to you, that there are a number of places where they have changed it, such as it's a very simple one, is the deposit is no longer states in there that it will be paid directly to the listing broker. It now has a blank there, and wherever the deposit is going to be paid, you fill in the blank. So if it's going to be the vendor's solicitor, you can now put that in without stroking something out and making an initial, so it's a little easier to use. While we're on the business of changes to the OREA form as of January 1st, if you, at the back of my article, I believe it's page 523, you'll find the OREA one there. I'll just tell you some of the changes that are proposed for January of 1997. At the top of the form, you'll see that it's the part that says, and having a frontage of blank more or less by a depth of blank more or less and legally described as. And then there is a long blank there, and underneath that long blank it says legal description of land including easements. When I first saw this form in 1994, and what I've been saying for the last year and a half as I've been doing it, is I never quite understood why they put easements there, because it seemed to me easements were also mentioned again in the standard pre-printed form down in title. And there also, if there was some specific easement, my understanding is that we're also supposed to draw the attention of that in the body of the offer if there's an unusual easement in there as well. Whether or not it's registered, or it's my understanding that's what my practice has been. I don't know about yours, but certainly I've never relied strictly on 10. It seems to me by having it up there, legal description of land including easements, it gave rise to a possibility that someone could say, no, you didn't put the easement up here in this blank, so, and you only relied on clause 10 there, we're dealing with title. What does this mean? What overrides, et cetera, et cetera. In 1997, January 1st, what the new form is basically going to say for OREA is it now says this, instead of just saying legal description of land including easements, it says legal description of land including easements not described elsewhere, which in my mind is a great improvement to the form and takes away from that possibility of someone raising an argument there. There's also another small change down at, basically in clause 6. I'm not really certain, they've got it here in terms of what it is in Clause 6. In Clause 6, as it currently reads, the second last line, when hand-delivered to the address for service provided for here, or provided herein. What it's now going to read is hand-delivered to the address for service provided in the capital A as an acknowledgement below. That's a small change there. In the next change is in Clause 7, which is the GST clause. The GST clause currently reads, the vendor agrees to provide on or before closing a certificate that the transaction is not subject to GST. As of January 1st, it says the vendor agrees to certify on or before closing that the transaction is not subject to GST. Again, there is no certificate, so it's merely a certification that the vendor is going to be giving here. I've already mentioned down at the bottom in 1997, OREA's got that clause that they hope will be included on all of them to try to avoid kind of changes there. On Clause 11, there is a small change there. It currently reads to the Loan Companies Act. This has been now changed in the third line to the Trust and Loan Companies Act Canada. In Clause 12, inspection now reads, the purchaser acknowledges having had the opportunity to inspect the property prior to submitting this offer. Now it reads, as January 1st, it will read, purchaser acknowledges having had the opportunity to inspect the property and understands upon acceptance of the offer. Going down to basically Clause 24, which is, I think, one of the most important clauses in the Agreement of Purchase and Sale, especially from the perspective of the sales representatives. This says that, currently reads, if there is a conflict between any provision written or typed in this agreement, including any schedule attached hereto and any provision in the printed portion hereof, the written or typed provision shall supersede the printed provision. The new one will read, if there is a conflict between any provision added to this agreement, including any schedule attached hereto, and any provision in the standard preset portion hereof, the added provision shall supersede the standard preset provision to the extent of such conflict. So those are the changes that are basically on the OREA form that are proposed. Now, I don't know the breakdown between who would in the room, or who will be viewing this, in between who uses the OREA form or the Toronto Real Estate Board form. Some of these are already in the Toronto Real Estate Board form, these changes, some are not, and I have little doubt that probably there'll be discussions between TREB and OREA to try to standardize the agreements between the two of them. But there are those subtle differences, and I have not heard as yet that TREB has adopted those. Now, one of the things when I go and talk to real estate brokers and real estate sales representatives, they have, it seems to me, and I mean no disrespect to them, they haven't, most of them, looked at the standard pre-printed agreement of purchase and sale and know what is in there since they took their courses. And I always stand up and I always say to them, if you're ever in front of a court and you're a witness of some sort or another, or a party arising out of a real estate transaction, are you going to be able to explain the provisions of the Planning Act clause to me? And they all look at me quite blankly, and maybe all the lawyers do as well. I know it's difficult to explain, but this is part of their responsibility and their duty to know what is in the standard pre-printed form of the agreement and to be able to adapt that and customize it for each individual transaction. And I think that's one of the most creative and one of the most exciting parts of the real estate sales rep's job, is to do that. And how well they do it, I guess that depends how well they do it, whether or not the agreement will go together without a hitch. Now, some of the major differences that they then go on to talk to them about is, and you might want to keep it open. I'll probably deal with the TREB agreement of purchase and sale. You might want to keep it open to page 5-19, which gives the agreement of purchase and sale there. The first thing that I ask them to notice after I explain to them they do have a duty and an obligation to know what is in the standard pre-printed agreement of purchase and sale is the first thing that I point to is the top of the agreement of purchase and sale and ask them what's missing. And the first thing that's missing is that there is no agency line now up there. Since this universal agreement of purchase and sale is designed to be a contract between the vendor and the purchaser, they have deliberately omitted any reference to the agents at this point. Then they ask, well, where do we appear? If you turn over onto the back of the agreement, there now is a new box. It's called the Confirmation of Representation. And there's a box on the left-hand side for the listing that has basically the name and the telephone number of the listing broker or the authorized representative. And then on the right-hand side, there's the part for the cooperating broker to fill in. Now, a cooperating broker, as you already understand, I hope, a cooperating broker can mean a selling broker, which is the same as a sub-agent of the vendor. It can mean a buyer broker or a purchaser's agent. It's not very often described as that, but it can also be that as well. So cooperating broker is a generic term. And basically, the big distinction between a selling broker and a buyer broker is to whom do they owe their duties. And this is where this is not the only place that they should be doing their disclosure and their confirmation of representation. Under the board bylaws and what CREA has promulgated and through OREA, they're supposed to be doing this at the moment they enter into the transaction. This is what Merv was talking about in terms of the paper trail that's there. A lot of the sales reps think that if they fill this in, that's all they have to do to establish their agency disclosure requirement, and that's not correct. The one thing that is also missing from this particular confirmation of representation, if a lot of the sales representatives act now as buyer brokers or in a dual agency capacity where they have two principals, and one being the vendor and one being the purchaser. The most important thing probably from the sales representative's perspective is who is going to pay me? And there is nothing here to say who is going to pay the cooperating broker. Now, OREA has developed a form that they use, which is a cooperating, Merv will correct me if I'm wrong, a confirmation of cooperation and representation that basically is to be signed as a separate side agreement between the listing broker and the cooperating broker to say how the cooperating broker is being paid. Now, when I was talking about my topic, Bob Aaron said to me, why do all the sales reps continue to put in an agency disclosure clause into the body of the offer? Well, the reason is most of them are not using, and I don't believe that TREB has this particular form, which is, there's no great magic in it. They used to have cooperating brokers agreements that were much simpler than this, but they aren't used frequently, is the reason the sales reps are putting in those clauses now into the agreement of purchase and sale, which is a contract, as we know, between the purchaser and the vendor, is because they want to ensure they're going to be paid. That's the simple explanation. Yes, it does screw up the agreement in terms of putting in something there that really has nothing to do with the agreement of purchase and sale, but that's the reality of the situation with it. And I hope that TREB especially will follow OREA's lead in this and start putting out more of these confirmation of cooperation and representation, because I think it's a very good idea to take it out completely from the body of the offer, because once you put it in the body of the offer, the vendors and the purchasers think that, yes, I can initial this, I can change this, I can make changes to anything I want. Once you open that up, as a sales rep, you open up that discussion to the vendors, especially, the vendors are going to take advantage of that to try to renegotiate the listing agreement and the amount of the commission that's paid. And you may have a vendor who says, I'm not going to pay a cooperating broker if it's a buyer brokerage situation, despite the fact they've probably already agreed to that in the listing agreement they've already signed, because it's already in there. But it doesn't get to the offer presentation table when the vendor realizes that they don't want to do this. Now, the next one that I usually go on to for the sales reps is I then talk about the deposit clause. And the deposit clause now says the deposit, and it's got a blank there, you fill it in. And then basically then it says the purchaser submits, and then there's it's brackets, and it says below this blank, herewith and upon acceptance. Well, once again, when you're dealing with the realities that you're usually, you being a lawyer, are not present when these offers are being drawn up, They're usually done around the kitchen table after they've had several introductions. They've gone through the properties 2 or 3 times. It's very different from what happens in our law practices in terms of the relationships that sales representatives have with vendors and purchasers. It's much friendlier usually. It's not usually as adversarial either. But basically, when we come to this, the purchaser submits herewith and upon acceptance. Purchasers, of course, always want to have upon acceptance. Vendors always want to have herewith. I think most sales reps, just whether they're not, and this again is a reality of the situation, most sales reps would probably, if they had their choice, and it is not their choice, this is the vendors and purchasers' choice, most sales reps would say, I want it also herewith, whether they're a buyer broker or not. Because although the deposit is no longer needed as important consideration into the deal, because it's now signed under seal, it still serves as a nice fund of money there that the sales reps can use and hope to use after the deal is closed to basically pay commission. So they usually like that there. But this is already an inherent conflict that is there between the vendors and the purchasers there. And that's the very first hurdle, I think, that the sales reps have to overcome when they are now using the agreement of purchase and sale, is to explain the consequences of this to the parties and make a decision as to how things are going to proceed from there. Although if you as a lawyer are acting for a purchaser, you may say, yes, we want upon acceptance, we want upon acceptance. If any of you have ever had problems getting additional retainer monies out of people, I'm certain you can sympathize with sales representatives who basically have a $500 deposit and then after the deal has closed without incident are left in the position of having to go after their commission. It's a fallacy, I think, to believe that the sales representatives in this kind of market are making enormous sums of money for very little work. Most of the very good sales reps work very, very hard. It takes a long time to put a deal together, and even longer if you're in the commercial or office leasing business, and a lot of them work very hard to do it. And I know we have a deep resentment in the legal profession against the amount of commissions that the sales reps get as opposed to our legal fees. Well, that's something that's been historic, and I don't know how we're going to resolve it. But I think the thing is it's not correct to take it out on the sales reps because of this. So this is the very first hurdle that is here, that the sales reps have to explain with the contradictions that are going to be inherent in the negotiation. The next clause that I usually draw the attention of the sales reps to is the notice clause, which is clause 6. And in this, it has resolved some of the case law because now the listing broker is appointed as the vendor's agent for the purposes of giving and receiving notices pursuant to this agreement. My understanding was that there's always been a bit of a gray area there. This has now resolved it. The next line goes on, if the cooperating broker represents the interests of the purchaser in this transaction, the purchaser hereby appoints the cooperating broker for the purpose of giving and receiving notices. If a sales rep is a buyer broker, then yes, the sales rep or the broker, whoever the broker is, representing the purchaser, they are basically appointed the agent of the purchaser. But if they are acting as merely a selling broker, no, they are not appointed the agent of the purchaser for the purposes of giving and receiving notices under this. And with the little clauses below for the fax number for delivery of notices to the vendor and fax number for delivery of notices to the purchaser, what I usually tell the sales reps is if you have private fax numbers that are placed down there for the vendor and the purchaser, you might be left out of the loop as to whether or not a condition has been met. So if the vendor or purchaser want to put their own personal fax numbers there, the listing broker should also put theirs there in that space. And in the space there that is for delivery of notices to the purchaser, the only fax number that should be there should be the purchaser's or the buyer broker's, not a selling broker. Because a selling broker is a sub-agent of the vendor, and you don't want to have any presumption here that a selling broker has been turned into an agent for the purchaser. The next clause that I usually go to then after that is clause 7, which is the GST clause. Yes?
Take it back to the positive paragraph. When they say upon acceptance, what's reasonable time for picking up the check once everybody's acknowledged that the deal has been duly executed?
Basically, upon acceptance means that that check should be ready right away in a perfect world.
So it's not, and then my vendor comes to me and says, you know what, it's been a day now. I've got a dying market, I want to get my property sold again. What do I tell them?
Well, at that point, you've got a problem. I won't go into the practicalities of it, but this question, which is, what do you tell a vendor if the deposit check has not arrived after a day after acceptance? That's the reality of the situation where you have this conflict between herewith and upon acceptance, a very practical reality of the situation. It's the same as if you have, in my mind, the same as if you have an NSF check. You're supposed to immediately inform your principal of the problem. That's the one thing you're supposed to do, and you're supposed to work diligently from there. At that point, if you have reasonable time, if it's not there within whatever a reasonable time will be, and that would probably be decided by the courts, but certainly within, I would say, 1 business day, it seems to me at that point, the real estate salespeople should be getting, unless there is something that is forthcoming immediately, they should be referred to their own legal counsel for a discussion of what is going to happen. The same as with an NSF check. Going on now to the GST clause, which is clause 7, does this, I usually ask them, does this clause solve all the problems? It used to be that the OREA agreement of purchase and sale had a GST clause, whereas the Toronto Real Estate Board one did not. In my opinion, all real estate transactions that have agreements of purchase and sale in Ontario should have a GST clause, the same as they should have a Planning Act clause. There should be no discussion about it. This one is difficult for the sales representatives to explain. Now, we're dealing, my paper has dealt exclusively with the residential field because the most of the transactions that go through are residential, and this form is for the residential use with it primarily, unless you've got sophisticated people who know how they can adapt this form for commercial use with it. And at this point, it says, if this transaction is subject to GST, then such tax shall be, and then you have again a blank, included in addition to the purchase price. If this transaction is not subject to GST, vendor agrees to provide on or before closing a certificate that the transaction is not subject to GST. Now, I think Bob Aaron in his paper, and as I said, I'm grateful to him for at the back of his paper where he described some of the problems with completing the agreement of purchase and sale and some of the practical problems. I believe Bob in his paper asked, do you know when GST is payable? Most of the sales reps have only a limited understanding of GST. I have to confess, perhaps mine is also limited. It's at times very complicated. But this is something that now the vendors and purchasers, you're sitting around an offer presentation here, or at the time the offer is being presented, you have, in reality, the vendors and purchasers are not sophisticated people such as ourselves. What they will do at this point is that they won't even know their mortgage terms, let alone what GST and how that impacts on them. The first thing to tell them, this is not the GST clause that relates to the GST that is payable on commission. The GST clause for the majority of transactions that take place in Toronto, the majority of them in residential, are going to be used residential real estate. Most of them will not have GST on it. But it's really not the place of the sales representatives to basically make that determination. But they have to somehow, again, with this conflict between included in and in addition to, purchaser always wants one, vendor always wants the other. They have to make an explanation of some sort to the vendors and purchasers to have this deal completed. The next clause that I want to very quickly skip to is clause 20. This is the Family Law Act clause, and this deals with the spousal consent. They now have a spousal consent clause that is down below the signatures there. But the new Family Law Act clause, the vendor merely warrants here that the spousal consent is not necessary to the transactions under the provision of the Family Law Act. One of the problems that arises is in this, it seems to me, that the basically purchasers are relying strictly on the vendor's warranty that is being given here that spousal consent is not necessary. Spousal interest may still be impacted. This clause that is in the agreement of purchase and sale does not take away from the duties and responsibilities of the listing broker and perhaps the cooperating broker, depending whether they are a sub-agent or whether they are a buyer broker, to determine whether or not spousal consent is necessary prior to the offer being developed. So this is a clause that is very interesting and I think fairly dangerous from the sales representative's perspective as to whether spousal consent is going to be required, whether or not this warranty is going to be sufficient to protect the sales reps as to whether the spouse's consent is necessary for it. The last clause that I'm going to deal with today, and you can read my paper because there's a lot of other differences there, and as I said, I've only highlighted some of the major differences. It's the UFI clause, which is clause 21. This clause will have to be adapted by many of the sales reps for houses where it did contain UFI at one time or it currently contains UFI. And this is one where they are going to have to make sure that they know what it means if there's a conflict to supersede. And this, again, this clause that is here with the vendor's representation and warranty will not stop the duties of the sales reps to determine prior to the offer being negotiated and drawn up as to whether or not the house has UFI in it. I hope that this has helped you with some of the very practical portions of this agreement of purchase and sale that I hope you'll be able to use and go and market to your clients and to use for those of you that are real estate sales reps and brokers with it. And if you have any questions, I'll be around after the presentation for a short period of time. Thank you. Is Mr. Chenoweth here? Oh, all right. Well, you may be on your own.
Maybe.
I think that Mr. Chenoweth is not able to be with us today. He may still be making it. I understand he's at trial. Mr. Drees is a member of the firm McDonald, Porter & Drees. He was called to the bar in 1985. He's represented members of the industrial, commercial, and investment real estate brokerage community for the past 10 years. He's also been an active participant as an instructor and author of the bar admission course materials and has lectured at various other continuing legal education programs.
Good afternoon, everybody. It's always nice to see ICI brokerage where it belongs, sort of at the end of the table somewhere. I'm happy to be here, and I thank Elizabeth for giving me the opportunity to speak briefly about some commercial brokerage concerns. My paper's found at tab 6 of these materials. For the purposes of today's discussion, what I hope to do is canvass briefly what amounts to the text of the paper and then go directly to some discussion topics that I put in at the end. I thought the discussion might be useful in highlighting some issues that come up on a more or less day-to-day basis in the legal practice of advising commercial real estate brokers. In discussing commercial brokerage concerns generally, I just want to bring to your attention what I believe is abundantly obvious, which is that the major distinction between commercial brokerage and residential brokerage is that the average commercial broker agent has considerably less control over the transaction or their respective client than the average residential agent broker does. The commercial agent broker is sometimes very peripheral to the transaction getting done. The reason for that is that the transaction, given its complexity or its sheer size, the financial costs involved, generally involve other experts, lawyers, consultants, engineers, architects, planners, and of course the clients directly. And frequently large commercial transactions are negotiated directly face-to-face between the vendor and the purchaser. The other significant thing is to recall that in many commercial transactions, and I'm sure all of you have seen examples of this, the broker agent involved is actually the party in the piece with the deepest pockets. I've been involved in a number of transactions which, for example, involve one of Toronto's major brokerage houses and two other parties, both of whom are receiving financing for the transaction, both of whom are taking the transaction in the name of numbered companies. If something were to go wrong with that piece, it's the agent broker. It's the agent broker that frequently winds up holding the bag and answering the questions, so to speak. I see Fred's just come in, so what I thought I'd do is just quickly summarize the rest of the beginning of this paper. It's to be stressed that in representing commercial real estate agents and brokers, you have to recognize their exposure and you have to act accordingly. Even though in some cases, and I think the fact situations will bring some of these up, you'll find circumstances where the broker, him or herself, itself, is not essentially liable for the conduct complained of. In many cases, it's the broker agent that's the easiest target. If you have two numbered companies who are essentially shells and a broker agent, it wouldn't take much to realize that most litigation lawyers will try to find a claim against the broker agent because they know there's money there. In discussing agency generally, I did put at the back of the paper some sheets identifying single agency and dual agency relationships, some of which can be created deliberately and some of which can be created accidentally. And they're there primarily to highlight just how innocently those relationships can be created from time to time. I'd like to draw your attention now, so that we can make constructive use of the time that's left to us, to page 6-8. There are some fact situations for discussion. What I propose to do is briefly canvass each fact situation and then give Fred and I an opportunity to sort of, throw our 2 cents on the table, and then any of you who have some questions about the conclusions that we may have drawn, feel free to chime up and we'll try to deal with them. I think that might be a constructive way to highlight some of the issues that we see on a regular basis. The first fact situation is found at page 6-8. I don't want to, well, I think it may be appropriate for me just to briefly canvass it. It says, listing agent broker for vendor of commercial condominiums obtains from a purchaser an executed offer to purchase which is accepted. I think the key words here is it has been accepted. Under the terms of the executed offer, the deposit of $50,000 is to be held in trust for the benefit of the purchaser until the completion of the transaction. The purchaser and vendor execute an amendment to the offer on the second page by which the purchaser agrees that the listing agent/broker may immediately take 1/2 of its commissions payable by the vendor from the monies held in trust. The commission transaction does not close, or the condominium transaction does not close through no fault of the purchaser. The listing agent broker has distributed the commissions taken from the deposit pro rata to the cooperating agent and the broker's own individual agent. The purchaser sues for recovery of the deposit, naming the vendor and the agent broker. Assume the vendor is judgment-proof and the claim proceeds against the agent broker. What is the agent broker's exposure here?
My thought is that the agent broker has an exposure. It's a kind of an unusual situation in which there appears to have been an amendment, but there's every indication that the commission was to be held until the completion of the transaction. And I think my sense from the case law I've been involved in, from the cases I've been involved in, is that you're going to find that the courts from time to time are going to have a concern about ensuring that the public is well protected, and with the phrase "to be held pending the completion of the transaction," in any event of the fact that there was an amendment which allowed the agent to take part of his commission at an early time, the fact that the commission had not been earned until the transaction had been completed is likely going to be foremost in the mind of the judge, and I think that in spite of that amendment, there's a reasonable prospect you're going to find that the agent has an exposure.
I'd have to agree with that from practical experience. We had a similar case which was litigated to the Court of Appeal. It involved a large condominium project. Several units had been sold with the same terms. The agent broker in this case was left holding a substantial bag as commission revenues had been received and dispersed to various parties, some of whom were not even still in the employ of the particular broker involved. We did our best to make a convincing argument that the purchaser had agreed to the amendment. The fact of the matter was that the court, not surprisingly, found that the intent was to have these monies be trust monies, and that the trust monies could not effectively be dispersed until the transaction had been completed. The fact that the transaction was not completed required those trust monies to be returned to the purchaser for whom they were being held, notwithstanding the fact that there was a sidebar agreement to allow the agent to take a portion of the deposit monies for its commission.
I think one of the points that's of significance here is that although you have these funds that are held by a broker or by any party allegedly in trust, and the agent has a sense that he has an opportunity to get at those funds, there's a concern about the fact that they're allegedly held for the purchaser, for some other party, and not necessarily the agent. And that's one of the hitches, I think, in the agent being sure that he can collect his check or his commission from those funds held in deposit. It was interesting, we had a case in which there was a direction, an irrevocable direction, to a law firm to hold a deposit of $50,000 pending the closing of the transaction. In spite of the fact that there was this irrevocable direction for the law firm to hold the funds, we wanted to get our commission, my client wanted to get his commission from those funds being held by the law firm, and felt that this irrevocable situation was going to protect him. In fact, they'd used the law firm for that purpose because there was some concern about the viability of the other parties involved. The law firm, in the face of that irrevocable direction, it was a substantial law firm as a matter of interest, received a second direction from his client revoking the earlier instructions, and the law firm sent the money off to the client. Well, of course, we were somewhat apoplectic about that, and we sued the law firm with every anticipation we'd get the funds back. To my surprise, when I took the time to research some case law with respect to the issue, I was a little shocked to learn that there's a divisional court case in about 1987, and it suggested that there was no consideration for the direction given by the client to the law firm to hold those funds in trust, and therefore the agent couldn't control that transaction because he'd given no consideration for that agreement that the funds be held in trust, and the client was at liberty to take those monies out of trust again. So I was faced with that divisional court case. Suffice it to say that the large law firm seemed to have some sense of moral fiber, and as a result of, well, actually more as a result of having to commence the lawsuit than anything else, we were able to resolve the issue. We got the funds back. But the point is that these funds held in trust are not inviolate. You're going to see some other areas of concern too. For instance, if there's a transaction that closes and there's some funds being held by a brokerage in trust, and your client is looking, your client broker or agent is looking forward to getting his piece of that commission. What happens when that brokerage house has some financial difficulties and goes into receivership or goes into bankruptcy? You're going to find the superintendent of real estate stepping in and taking hold of all of the funds, including the funds held in trust. And again, to my surprise, I have found on, I think, at least 2 occasions that I was unable to get those funds out of that brokerage, even though they were in trust in that particular transaction, and get them for the benefit of my client, because the superintendent was taking a position that all of the non-real estate people, all of the public were required to have their concerns satisfied from those funds prior to the time that any of the agents or brokers were going to get their dollars. So the fact that these funds are held in trust is useful, but not always completely satisfactory.
With respect to that, the listing agreement, if there was such one, the commercial brokerage and the vendor, wouldn't the listing agreement say something about only payable upon completion, or maybe there was nothing with respect to that? So before completion, are they obligated, if they don't have that only upon completion, pay commission in the listing agreement, can they not dispense the funds to the brokerage house?
Can you repeat the question to the mic? Repeat the question to the microphone.
I'm not sure I completely understood the question, but you were saying that if the
If the brokerage has taken money, paying their agent, okay?
yes.
And you say that money is held in trust for purchasers, and you should not touch that money unless there's a completion on the project.
Correct.
But if the listing agreement with the brokerage house and the vendor says that the vendor will pay the broker the commission, shouldn't it say only upon completion? Maybe it didn't say that.
It didn't.
Okay, so you're still saying it's not right to take that money out.
The
Because it's trust money from the purchaser.
The important thing to bear in mind here is that broker-agent relationships with the parties that are paying them, let's assume for the moment it's traditional and it's the vendor, are distinct, separate, and apart from the relationship that exists from a vendor and between a vendor and a purchaser. If the terms of the agreement between the vendor and the purchaser stipulate that those monies are trust monies to be held in trust until completion of the transaction, or frankly, if it just says that they're trust monies, the fact that the vendor may have agreed with the listing agent broker that they can take the money, bear in mind that there's real liability there if the vendor disappears at the end of the piece, the agent's taken the money, and in this case, the deal didn't go through.
That contract is between the vendor and the purchaser as opposed to between the agent
That's right.
and the
But
vendor.
there's also a contract between the listing broker and the vendor. If you prefer an offer, whether it goes to completion or
Right.
the project is dissolved, and they've got to the point of getting 50 clients to buy it, you're still saying they shouldn't take that extra money.
But that contract was with respect to the vendor's obligation to pay a commission to the agent, as opposed to the contract that spoke to the monies being held in trust, which was the agreement of purchase and sale between the purchaser and the vendor.
Fred made a very good point with respect to directions. A lot of agents think that because there's a little paragraph at the bottom of page 2 that says irrevocably direct that so-and-so will hold the monies and they can take their monies from that particular deposit, those directions can be changed. There is no privity of contract in an agreement of purchase and sale between a commissioned real estate agent broker and one of the parties to that agreement. The way we try to get around it sometimes is that we draft very exotic wording, which essentially creates a contract within a contract for additional consideration for a particular concession, i.e. an irrevocable direction. Because you can definitely change those irrevocable directions. And agents have a heck of a time enforcing them because they're not a party to the agreement by which they were created, even though the direction is for the benefit of the agent.
Should we try number 2?
Yep.
Sorry, what if in an offer, instead the deposit, initially deposit into the lawyer's trust account, but the vendor, the builder has the right to withdraw those funds before the completion of transaction.
Yeah.
So is the lawyer protected?
Is the lawyer protected? Well, I would have thought that the lawyer doesn't have a difficulty if he's taking the direction of his client, and it's stipulated that he has the right, the client has the right to withdraw the funds prior to the completion. Would be my sense of things, and again, I suppose that the lawyer is going to rely on the fact that the consideration with respect to that particular contract is a consideration that flows between the purchaser who's paying the deposit and the lawyer, and not between the agent who's looking for that deposit. Unless, as you've done, unless someone has done what Yen suggests, and that is to try and create some sort of a flow of consideration between the agent and the vendor, or the agent and the lawyer, which vis-a-vis that agent or vis-a-vis that vendor makes for a consideration for that irrevocability and means that it can't be withdrawn. So you've got to build in the kind of protection that Jens is talking about before you can stop that contract from being, that money from being taken back.
Perhaps one way that the lawyers could protect themselves if they had any doubt about whether there was an irrevocable direction or not, or whether this contract within a contract had been made, would be the simplest way for the lawyer to protect himself or herself would be, of course, to interplead the monies into court.
The Law Society came up with a direction a couple of years ago to lawyers to pay the money recorded in circumstances where there was an irrevocable direction.
The Remax Gardens.
The issue was the seal or no seal, and I think that means it's not the case that there's no seal. Realtors
Correct.
have been advised to ensure that there are seals. Now the forms have pre-printed seals, and the Law Society direction to us was to if this problem arose, to simply get it.
That's the Remax Garden City case, which basically is the one that said that the seal imported the consideration in terms of that when you're talking about after a deal has completed, which is different from the fact scenario these gentlemen are talking about, that is still imported into the new universal agreement of purchase and sale to basically with that. And yes, they are suggesting, and it has been upheld, I believe, again in a, I know of an unreported small claims court matter where again it was also upheld that there was a seal there, that it was upheld in the small claims court, the Remax Garden City case in terms of that. I think the fact scenario these gentlemen are discussing are a little bit, they're just also drawing some attention to the point that an irrevocable direction, unless that there is some kind of consideration, can perhaps be withdrawn. And that's always a possibility because the question was in terms of instructions of clients to lawyers as to whether or not there has been a contract within a contract, whether there has been sufficient consideration to give some kind of, this is basically also dealing with the equitable assignment of a portion of the proceeds of sale with the Remax Garden City case.
Wait, okay, go ahead.
You know, you want to get on, but if you did have wording like this, where it says the deposit itself for the benefit of the purchaser, Has that ever been litigated that somehow impacts on the vendor's right to claim default of the deposit if the purchaser defaults under the deal?
Sure. It's litigated all the time. The problem is it's a matter of fact whether the purchaser is defaulted or not. And in some cases, that can take years to establish successfully. You can't go pinching the money before that has been established, because in the event the purchaser is successful in asserting the right to it, you could wind up in the position of having to repay.
So even if he is default, and that's a fact, is the self-pay benefit, where's the entitlement of the pay?
Usually, and this wasn't intended by this question, usually there's wording in any offer that in the event the purchaser defaults, that those deposit monies go to the vendor as liquidated damages, for example. So you wouldn't have that situation too bad. Number two, agent finds a tenant for the owner of a property. The tenant takes space for a 5-year term with a 5-year renewal option. Agent is to be compensated by way of commissions from the landlord on the lease and any renewal thereof. Prior to the tenant formally notifying the landlord of its intention to renew, the agent visits the tenant and suggests the agent can find the tenant better space elsewhere at less cost, and that the agent can assist the tenant in negotiating the best possible renewal terms. The landlord gets wind of the agent's activity and sends a scathing letter to the agent. Has the agent done anything wrong?
I think the agency relationship is kind of a special one. You probably are familiar with some of the Supreme Court of Canada cases that talk about. You're probably familiar with some of the Supreme Court of Canada cases that talk about the development of a fiduciary relationship and some of the indicia that go into the development of that. My sense of things is that the agency relationship is a relatively special one, and that the agency relationship in itself, even in the absence of some of the other elements of fiduciary relationship, is in fact a creation of that fiduciary relationship. And I think this agent is exposing himself to an action for inducing breach of contract when he goes to that tenant and is taking that tenant to other locations, possibly other locations where he feels he can get a commission for this, or a better commission even, and possibly even a renewal situation if there's a renewal on that lease. So I really think there is an exposure for the agent. I think he's a fiduciary of that landlord, and I think when he takes the tenant out and tries to introduce him to other properties, he does so at his peril. And really what you're talking about here is you're talking about trying to reduce the prospect of your client being shot at in a lawsuit. And the essence, I think, of acting for some of the brokerage houses on an ongoing basis is this concern about trying to reduce their exposure and trying to avoid the necessity of finding them in these ongoing lawsuits that frankly cost them a good deal of money. And if an agent of one of my brokers was in that kind of circumstance, I'd be quite concerned that he was going to expose himself to a real potential for a lawsuit.
I think what this highlights, and those of you that work in the brokerage community are undoubtedly aware, that there is a domino effect between acting for landlords and tenants, and that there is a symbiotic relationship between them. You've got to be careful, particularly in cases where there's a renewal option, which makes it clear that on any renewal you're receiving a commission, that you don't tread on that because it creates a fiduciary obligation, which of course can be the basis of litigation. Yeah.
What's your dual agency in the initial lease? And perhaps the tenant call the agent and ask if there were better deals. Would you consider that still the same situation?
I was just going to posit that question because I think it tightens it up a little bit. Let's say the situation is that rather than the agent calling the tenant and see if he can find him another deal and maybe get a better commission, the tenant, as our friend is asking, calls the agent and suggests, hey, I'm about to go into a renegotiation with my landlord. Before I do that, and I know I've got myself a firm deal here, can you show me some other places? Is there a risk there for the agent? And frankly, I think it's a good question. And even though the agent's been contacted by the tenant, should the agent get involved in showing that tenant other properties? My sense is that he can do so. My sense is that legally he's on reasonably firm ground. But I think there is some concerns about some possible exposure there. And it may be that the agent or the brokerage house for whom he acts might consider doing certain things to try and protect themselves from that kind of an action.
The thing is, if there is dual agency, bear in mind your commission revenue does come, in most cases, from the vendor. If there is a right to payment on a renewal, as this particular fact situation posits, be careful, because that deposit right establishes an interest in the renewal and a fiduciary, an ongoing fiduciary relationship. I would be very cautious about proceeding to show the tenant other space in those circumstances. If there wasn't a commission entitlement on a renewal, I think that would change the matter for the better.
It may be that you'd want to consider maybe trying to protect your agent if he chose to go into that situation. Maybe he should be protecting himself by some sort of correspondence to the tenant indicating that it's your request. I've done a computer search, and this is you've asked me to do that in any event of your ongoing relationship with so and so. I think you'd want to build in some protection for him, even if he was asked by the tenant to make these inquiries.
Do commercial brokerages not use some form of confirmation of representation, as we've been referring to earlier, that's common to residential transactions? And if they were to use that form and confirm that you are a tenant's agent, it seems to me that at the time of renewal, it can't be an inducing of a breach of contract, since the contract can expire at the option of the tenant.
Yeah, you're changing the fact situation a little?
Well, I guess what I'm asking is, what I don't understand is, why wouldn't brokerages, commercial brokerages, use a confirmation of representation form?
They do.
If that's the case, then why do we have this vagueness as to who is acting for whom?
The reason you have a vagueness is because when the landlord when the tenant is gone somewhere else and the landlord is looking for someone to sue because the tenant is gone and the tenant he can't find him, or the tenant isn't of substance and he's got a vacant property, he's looking around for some way to collect his money, and that's where the problems arise. And the question is, what is the degree of exposure that your client has? And that's really what you're talking about. And then you get into knotty questions about, I mean, how far am I going to defend this claim? Am I going to send some money to these people? Am I going to invest my money in legal fees? Am I going to invest my money by trying to ameliorate the concerns that this individual has? Or am I going to simply tell them to go away? And what you've got to do is find the maximum way of protecting your clients from those kinds of knotty problems. And you're right, the form is obviously the way to do that. But regrettably, people just don't seem to use those forms.
There's also some historical background as well in terms of the commercial and office leasing. Office leasing for years used tenant representation letters, but basically would go out then to the various landlords and be paid by the landlords. So they actually, for a long time, had a lot more of things that were not highlighted as much as being highlighted in the last few years with the agency disclosure requirements. So there are some historical things in terms of the commercial and office leasing as well, in terms of how they have basically developed, and the sophistication of vendors and purchasers in commercial properties, in land assembly deals, which basically again gets back to buyer brokerage and gets back to various things. They are supposed to be using, though, the same agency disclosure requirements that CREA brought out are supposed to be used by them, but there has been, office leasing was always an interesting, 4 or 5 years ago, was very interesting because of the tenant representation and mandate letters that they did use, and yet were paid by the landlords. They would go out and get specific representation.
Recognize as well that the CREA disclosure forms do not necessarily ensure a complete fit. If you're a tenant, a buyer broker, for example, or let's not use that's a bad example. Let's say you're acting for a tenant and you're being paid by the vendor on a particular piece. The vendor may pay you for your representation of the tenant to ensure a lease has taken place as a sub-agent of the listing agent. But there are still always issues around renewals that don't necessarily get considered in the original representation arrangement. So be cautious of that, because some of these transactions, agents make money every day sitting in their office on renewals, options, and things of that nature. We've got 5 minutes left, so I think I'd like to go to question 5. Question 5 talks about the agent as the listing agent for the owner of raw land recently rezoned to permit residential development under the terms of an executed listing agreement. The agent and the landlord jointly agree to market the property for residential development. The agent finds a builder who is in the process of negotiating the purchase of the land for the construction of residential townhouses. During the course of the negotiations, the agent has reason to contact the previous owners of the site who operated a distribution warehouse at the location. In the course of discussions with these owners concerning issues indirectly relevant to the agent's activities, the agent is made aware that the property was formerly used by a metal plating plant and that there had been numerous allegations during the distributor's ownership of the site that the soil was toxic. The previous owners did not clean up the site and sold the site to the present owner at a significant discount to reflect this fact. The new owner has managed to rezone the property without cleaning it up. The agent contacts the owner to advise the owner that there may be environmental issues with respect to the site. The owner says, "Don't worry about those issues and don't say anything to the buyer." The agent protests that the buyer intends to build townhouses on the site. The owner says, "You're my agent and you keep your mouth shut." Does the agent have exposure here? To whom and for what?
Is this agent an officer of the court? You almost get into the same squeeze you are from time to time as an officer of the court and as a representative of your client. I think I think that what you must do in this kind of situation is tell your client that there really is two issues that are involved. Obviously, there's an ethical issue, and he's got to respond properly to that ethical issue, and not to demean the ethical issue. I think it's the most significant issue. My sense is that the response to the ethical issue is a clear one. But I think the way that you're going to have to sell this from time to time to your client is on the basis of the economics of the situation. In my view, and my experience in these matters tell me that I think there's an obligation on an agent to at all times disclose to all parties involved any matter that significantly affects the value of the property that's at issue. I think that's an ongoing obligation of the agent, and it's an overriding ethical obligation that I think he has. The agent, of course, has a concern. This is going to be one of his better clients. This is going to be the chap that he's known for a long period of time, that he gets most of his business from, and he's being told, "You're my agent, you're my pal, you're my long-standing business relationship. Don't tell these people about this problem." Your fellow's going to be in a bit of a dilemma, and I think you're going to have to help him with that dilemma. You're going to have to tell him that in the long run, his word and his ethics are going to be extremely important to him, even with respect to his relationship with this particular client. And I think he has the obligation to disclose, or at the very least, and one wonders whether this is going to be adequate, at the very least, I think he may have to tell this individual that he can't continue to act as his agent through the course of this transaction. At the very least, in my view, he's got an obligation to probably take that position with his client.
It's important for those of you advising brokerage houses, residential or commercial, to recognize that I've always, and perhaps not a perfect metaphor, but I always view the brokerage house as sort of an aircraft carrier. You know, deals land, deals leave, but the aircraft carrier sits in the water and has great vulnerability. In circumstances like this, it's a very tough nut to crack because you have a risk, of course, that if you make the disclosure that you blow the deal for your vendor. You have a fiduciary duty to the vendor. Query whether in disclosing the information you've breached your fiduciary duty to the vendor. You're going to be responsible for all the damages the vendor incurs as a result of this breach. On the other hand, if you're acting for typical vendors, numbered companies who take monies and money hits the bank account of the numbered company and they're gone, query whether at the end of the day, when the developer finds out that they can't sell any of these townhouses or that they're sitting on Love Canal 2, you're going to be the one holding the bag for what may really amount to, at the very least, a misrepresentation and perhaps a criminal fraud. So it is a tough nut to crack, and I have to agree with Fred in this case that you're erring on the side of disclosure is generally the safer way to go. But recognize this is a case that has in fact happened to me, And, I had to pull an Eddie Greenspan on this and say, look, is there some way you can let the other agent know that they shoulda, woulda, coulda, oughta maybe take a look at some of the environmental issues around this site without exactly telling that agent that there is a problem. We did that, and it started to percolate through the chain, much as you'd expect it would, and then eventually became a problem that had to be addressed. But it's a delicate issue because you have liability both ways.
The issue really that the only reason you have to disclose it is as a matter of law, the vendor has to disclose it. I mean, just to take another example, let's say you found out that the federal government was about to appropriate some land nearby for a prison. Maybe you breach piece of information.
Yeah, but there's two issues here. I mean, if we take the worst case scenario where you are, I don't believe that this necessarily means you're obliged by law to disclose it, because all you know is that there is maybe on the come some problem that's environmental. You're not privy to all the information. For all you know, the vendor's got a report saying, hey, it was toxic, it's not anymore. You make the disclosure, you blow the deal, you've got a big problem. With an expropriation, I mean, yes, maybe you ought to, but query again, who are you the agent of? Where does your fiduciary duty lie? Whose call is it?
I'm agreeing with you. I can't see if you're talking about an agent here that's strictly a vendor's agent, you don't get involved in all the other.
Right.
You've got a clear fiduciary duty. And unless you're starting to bridge on, as you indicated, fraud and being a participant.
Right.
I don't see how you
Just before we leave, everybody recognizes that if this was a dual agency situation, how the stakes would go up dramatically.
Any way you cut this thing, you're open to some potential for some serious litigation. If you back out of this deal and don't disclose, and there's some statements of claim that later come forward alleging some frauds, there may be a reasonable prospect that the agent who didn't disclose and who took the position, I'm simply going to back out of this deal, he may in any event find himself as a defendant in that lawsuit.
Well, what I was trying to get at is, would it be good enough, do you think, to send a letter, and do this formally through the lawyer or whatever the case may be, to make sure that you're serious to your client, then saying, in our view, you have to disclose.
Yeah, but you see, the big problem down the road is that your numbered company that holds the land gets paid and is gone. This letter shows up in the course of production somewhere. I mean, the situation just got worse, because now not only do you know about the problem, you've adverted to it, you've advised on it, but you haven't made the disclosure. So on the flip side of that case, you're now even in worse shape.
I'd have a tendency to send the letter, I think. I think that you want to take the high road as much as you can, and it's a tough call. What you've got to design in some of these circumstances, and I think you're right, this is a kind of an intractable problem, and you'll find many of these problems are intractable. And I think one of your responsibilities is to try and design the best protection you can for your client on an ongoing basis. If you can paper it, if you can send a little letter, even if it's a self-serving letter, you got to find some way of maybe putting him in the best light should the lawsuit start to fly.
I think the backing out is also a viable option. I mean, something that you could do that wouldn't necessarily spill the beans on anything, but would get you out of the line of fire in the event a problem did arise.
Well, I'd like to thank you all for coming, and I'd like to thank all of our faculty members as well, and have a happy Halloween.